afternoon to you all here today. My name is Dilip Sogi, and I'm the acting spokesperson for the Public Protector South Africa. Thank you all for the invitation to media briefing for the first quarter of 2023-2024. Colleague on her immediate right is the CEO of the PPSA, Ms. Thandi Sibanyoni, and on the immediate left of Advocate Galeka is the acting COO, Advocate Nelisiwe Ngabile. Duration of the briefing, I'm going to hand over to Advocate Galeka. Take 3 rounds of 4 questions each. When you ask your questions, please be so kind as to introduce yourself and to tell us.
South Africa, investigators, provincial managers, media present today, South Africans, ladies and gentlemen, I greet you all. It is truly humbling and encouraging to witness your interest in the work of our institution. The Public Protector South Africa is South Africa's most crucial constitutional institution that is designed and established to strengthen our constitutional democracy and bolster the efforts of the people of South Africa in exacting accountability in the exercise of state power and control over state resources through administrative scrutiny. We utilize media briefings to keep the people of South Africa abreast of the developments in our investigations and to fulfill our obligations under Section 182, subsection 4 of the Constitution, to be accountable to all persons and communities. Without the involvement of the media, this would not be possible. We therefore take this opportunity to express our gratitude for your presence here today and for your patience as we started the formal briefing a little bit later. We have invited you today to publish 12 reports which are signed at my level as the acting public protector, but I also wish to announce that for this first quarter, which ends today, for the 2023-2024 financial year, the institution has finalized 1,425 matters that encompass matters which are classified as good governance and integrity, early resolutions, and predominantly service delivery matters or service delivery related matters which affect the ordinary people at the grassroots. These investigations are concluded and signed by the PPSA officials ranging from the executive managers who are seated here today, provincial managers as well as chief investigators. I further take this opportunity to thank the entire team for their sterling work in overseeing and ensuring the finality of these matters, many of which have had an invaluable impact on the lives of many people of South Africa. As an institution, having learned from the judgments of yesteryear, we have been steadily improving the quality of our investigations by, amongst other things, establishing rigorous quality assurance processes, revising our assessment procedures, and creating a training regime for our staff at all levels, both in our core business and support services. The results have revealed themselves gradually through improved working relationships with our stakeholders, a sharp decrease in litigation stemming from our reports, and improved cooperation between the institution and parties to investigations. We are confident that now, more than ever before, our reports are built to last and are prepared for any degree of legal scrutiny With the interventions that we have put in place, we can only improve further in leaps and bounds. We have also successfully rolled out our case management system, which represents a significant step in our goal of digitizing the institution. The system has made it easier for us to track our workload and respond timeously to affected and implicated persons during the course of investigations. We continue to migrate our brown folder files into digital form and look forward to the completion of this phase of our digitization project. This will also improve the turnaround times of our investigations. The reports communicate the results of our investigations and provide accountability and a degree of transparency to the public for the office. The goal is to clearly, concisely communicate the complaint, what evidence was obtained, examined, found relevant and significant, the laws governing them, and the analysis conducted to reach the conclusions found in the reports. The findings of these reports are published in terms of Section 182(5) of the Constitution, read with Section 8, subsection 1 and Section 8, subsection 2, capital AA of the Public Protector Act 23 of 1994. In terms of this legal framework, the Public Protector South Africa's investigation reports must be published and findings must be made known to any person in a manner the Public Protector deems fit, unless exceptional circumstances require that the reports be kept confidential. At this point, it is prudent to emphasize the approach to our investigations, which includes an analysis of the relevant documentation, interviews and application of relevant laws, regulatory framework and prescripts. We approach our investigations using an inquiry process that seeks to determine A, what happened, B, what should have happened, C, is there a discrepancy between what happened and what should have happened, and does that deviation amount to a violation of the executive code, or does that deviation amount to maladministration or improper conduct? And D, in the event of a violation of the executive code, maladministration or improper conduct, what remedial action should be taken? The question regarding what happened is resolved through a factual inquiry carried out by gathering sufficient information and evidence obtained from the parties and independently sourced by the investigation team to enable the issues to be adequately addressed by proving or disproving matters relevant to the issues being investigated. This information is then assessed to establish the reliability and admissibility of the evidence. I now, in no particular order, take you through just on the 12 reports, which I will just state which reports they are, and then it is 2 reports which I am going to read out here this afternoon. We've got the report of Mufamadi versus the Department of Military Veterans, Mashaba versus Ekurhuleni Municipality, Andani versus the University of Cape Town, Hlela versus Transnet, Sithole, the Performing Arts Center of Free State, Makakula versus the National Lottery Commission, Mayimela versus Mushwana, Sibohodi versus the Salt Blackie Municipality, Human versus State Security Agency, Maluka versus Mpumalanga Department of Education. And these can be accessed from our website on www.pprotect.org. Allow me to proceed then to read report number 07 of 2023-2024. This is a closing report that relates to an investigation into allegations that the President of the Republic of South Africa, Mr. Cyril Matamela Ramaphosa, the President, and the Minister of Justice, Mr. Ronald Lamula, violated Section 175(1) of the Constitution of the Republic of South Africa and the Executive Ethics Code in the appointment of Judge President of the Gauteng Division High Court, Johannesburg, Judge President Dustin Mlambo, as an acting Justice of the Constitutional Court of South Africa. In this matter, we received 2 complaints from Ms. Papano Pasha as well as from Mr. Floyd Shivambo MP on the 7th of February 2022 and the 25th of March 2022 respectively. Ms. Pasha alleged that on the 30th of April 2021, the Chief Justice of the Con Court, Mogoeng, who is the former Chief Justice now, recommended Deputy Judge President Matondo and Judge Rogers to act as judges of the Constitutional Court, and the Minister responded 2 months later on the 2nd of July 2021 to the then acting Chief Justice of the Constitutional Court, Chief Justice Zondo Current, that Judge Mlambo be one of the candidates to be considered and recommended to the President for appointment to act at the Constitutional Court. On the 9th of July 2021, Chief Justice Zondo informed the Minister that it was too late for him to give concurrence that Judge Mlambo be recommended to the President for appointment as an acting judge of the Constitutional Court. However, on the 8th of November 2021, Chief Justice Zondo capitulated and concurred that Judge Mlambo be recommended to the President for appointment as acting judge of the Constitutional Court. During the interviews for the position of Chief Justice, which were held in January 2022 by the Judicial Services Commission, Chief Justice Zondo was asked about the decision of the Minister to suggest Judge President Mlambo to him as one of the candidates to be recommended to the President for appointment as acting justice. Chief Justice Zondo responded that the actions of the Minister was not norm and was unusual, and that the action of the Minister can be perceived as a violation of Section 175(1) of the Constitution, which provides that, I quote, "The President may appoint a woman or man to serve as an acting deputy Chief Justice or Judge of the Constitutional Court if there is a vacancy in any of those offices or if the person holding such an office is absent. The appointment must be made on the recommendation of the cabinet member responsible for the administration of justice, acting with the concurrence of the Chief Justice," I unquote. Further, Mr. Shivambo related complaint alleged that a response by Judge President Mlambo during the interviews of the position of Chief Justice of the Constitutional Court in January 2022, that he was told that the President was the person behind his appointment to act in the Constitutional Court is circumstantial evidence pointing to the conclusion that Judge President Mlambo was the candidate preferred by the Minister or the President for the position of Chief Justice, and the conduct of the Minister and the President were unlawful and unethical and aimed at judicial capture and a manipulation of the rules to ensure that Judge President Mlambo gained an unfair advantage in the selection process for Chief Justice. Therefore, their conduct amounts to a breach of the Executive Ethics Code as well as Section 96 of the Constitution, including the relevant oaths of office taken by the two cabinet members. The issue for determination was whether the Minister of Justice and Correctional Services, Mr. Lamula, violated Section 175, subsection 1 of the Constitution when he suggested Judge President Mlambo to Chief Justice Zondo for concurrence and recommending him to the President for an acting appointment in the Constitutional Court, and if so, whether such conduct was unlawful and unethical and contravened Sections 96, subsection 1, subsection 2b of the Constitution, and Clause 2, subsection 1b and c of the Executive Ethics Code. The following conclusion is reached. Section 175, subsection 1 allows the President to appoint an acting Constitutional Court judge under certain circumstances, while Section 175(2) empowers the Minister of Justice to appoint acting judges of other courts. In both cases, the appointments are made without consulting the Judicial Services Commission, but with the concurrence of the Chief Justice, and after consultation with the senior judge of the particular division. The Constitutional Court dealt with the appointment of acting judges during the certification proceedings of the text of the Constitution and stated that, I quote, The appointment of acting judges is a well-established feature of the judicial system in South Africa. Such appointments are made to fill temporary vacancies which occur between meetings of the JSC or when judges go on long leave, are ill, or are appointed to preside over a commission. These appointments are necessary to ensure that the work of the courts is not disrupted by temporary vacancies or the temporary absence or disability of particular judges, I unquote. Section 175(1) of the Constitution does not dictate who between the minister and the Chief Justice should suggest the judges to act in the Constitutional Court, but requires that there be an agreement between the minister and the Chief Justice before the judges are recommended to the President. It is therefore not clear whether the remarks of the Chief Justice regarding the minister's actions being contrary to norm and unusual were made in respect of the appropriateness of the particular recommendation, as the Chief Justice would be undoubtedly be aware that the minister is constitutionally authorized and obliged to recommend an acting appointment with the concurrence of the Chief Justice. The Constitutional Court also dealt with the provision allowing for the appointment of an acting Constitutional Court judge. At the time of the certification proceedings, the provision required the appointment to be made by the President on the recommendation of the Minister, acting with the concurrence of the Chief Justice. The Constitutional Court dealt with the objection as follows, and I quote, "Appointment of an acting judge to the Constitutional Court is in a special category. The Minister of Justice and Chief Justice and the President of the Supreme Court of Appeal are members of the JSC, and the requirement that there be agreement between them as to the person to be appointed meets any reasonable concern that the power of appointing an acting constitutional judge might be abused," I unquote. The Constitution was subsequently amended. The amendment, Section 175(1) requires the President to make the appointment on the recommendation of the Minister and the Chief Justice only. The amended provision therefore only requires the concurrence of one senior judge and not two, as was previously required. It should be noted that when Chief Justice Zondo did not give his concurrence to the Minister did not proceed to recommend to the President that Judge President Mlambo be appointed as acting judge of the Constitutional Court for the period of 1 August 2021 to the 30th of September 2021. The Minister therefore did not contravene Section 175 subsection 1 of the Constitution. Section 96 subsection 1 and subsection 2b of the Constitution require a member of Cabinet, in this instance the Minister, to act in accordance with the Executive Ethics Code and to not act in any way that is inconsistent with his office or expose himself to any situation involving the risk of a conflict between his official responsibilities and private interest, respectively. Whereas in terms of Clause 2.1 of the Executive Ethics Code, the Minister is required to perform his duty, including his constitutional obligations, diligently and honestly, and in this instance, his duty to recommend judges to the President for appointment of acting judges in the Constitutional Court. The complainant's contention is that the conduct of the Minister in suggesting Judge President Mlambo to Chief Justice Zondo to be recommended to the President for acting appointment in the Constitutional Court for the period of 1 August 2021 to 30 September 2021 was to give him an unfair advantage to be appointed Chief Justice of the Constitutional Court, therefore breached Sections 96 subsection 1 and subsection 2b of the Constitution, read with Clause 2.1 of the Executive Ethics Code. The investigation revealed that it is not the first time Judge President Mlambo was identified for an acting appointment in the Constitutional Court. The evidence further reveals that he was appointed as acting judge of the Crown Court for the period of 16 January 2022 to 30 March 2022. On both occasions, he was suggested by the former Chief Justice and he declined. He was later suggested by Chief Justice Zondo. he accepted and he was appointed as acting justice in the Constitutional Court. At all occasions, it was not the minister who suggested him to be appointed as acting justice in the Constitutional Court. The minister suggested to Chief Justice Zondo to consider Judge President Mlamba for concurrence to enable the minister to recommend him to the President for acting appointment in the Constitutional Court for the period of 1 August 2021 to 30 September 2021. Chief Justice Zondo did not give concurrence, and Judge President Mlambo was neither recommended by the minister nor appointed by the President as acting justice for the Constitutional Court. However, Judge President Mlambo was, on recommendation of the Chief Justice, appointed by the President as acting justice in the Constitutional Court for the period of 16 January 2022 to the 31st of March 2022 on recommendation by the Minister, dated 23 November 2021. Section 175(1) of the Constitution requires the Minister, with the concurrence of the Chief Justice, to recommend judges to the President for appointment as acting judges in the Constitutional Court. The conduct of the Minister in particular, that is, to suggest the name of Judge President Mlambo for acting appointment to Chief Justice Zondo, was not inconsistent with Section 175, subsection 1 of the Constitution. Therefore, the conduct of the Minister in this regard was not in breach of Section 96, subsection 1 in subsection 2b of the Constitution and Clause 2.1 of the Executive Ethics Code. Accordingly, it was found that the allegations that the Minister of Justice and Correctional Services violated Section 175(1) of the Constitution when he suggested Judge President Mlambo to Chief Justice Zondo for concurrence and recommending him to the President for acting appointment in the Constitutional Court, and therefore breached Sections 96, subsection 1 and subsection 2b of the Constitution and Clause 2.1b and c of the Executive Ethics Code is not substantiated. On the second issue, whether the President violated Sections 171(1) of the Constitution when he appointed Judge President Mlambo as acting judge of the Constitutional Court, and if so, whether such conduct was in breach of Section 96, subsection 1 and subsection 2b of the Constitution and Clause 2.1b and c of the Executive Ethics Code, the following conclusions are reached. Section 96(1) and 2b of the Constitution requires a member of Cabinet, and in this instance the President, to act in accordance with the Executive Ethics Code and not to act in any way that is inconsistent with his office or expose himself to any situation involving the risk of a conflict between his official duties and acting judges in the Constitutional Court diligently and honestly. Section 175(1) of the Constitution enjoins the President in appointing acting judges in the Constitutional Court to do so on recommendation of the Minister acting with the concurrence of the Chief Justice. The President appointed Judge President Mlambo to act in the Constitutional Court for the period 16 January 2022 to 31 March 2022. This was after Judge President Mlambo was recommended to the President by the Minister on the 23rd of November 2021, acting in concurrence with Chief Justice Zondo. When appointing Judge President Mlambo, who was recommended by the Minister acting with the concurrence of Chief Justice Zondo, the President fulfilled his constitutional duty in terms of Section 175(1) of the Constitution as required by Section 96(1) and 2b of the Constitution, read with Clause 2.1 of the Executive Ethics Code, which requires the President to perform his constitutional obligations diligently, honestly, and in the best interest of good governance. The President appointed Judge President Mlambo as acting justice of the Constitutional Court for the period 16 January 2022 to 30 March 2022 on receipt of the recommendation from the Minister dated the 23rd of November 2021, indicated that he had the support of the Chief Justice in terms of Section 175(1) of the Constitution. We thus could not find evidence that the President had violated Section 175(1) of the Constitution at the time he appointed Judge President Mlambo as acting justice in the Crown Court. Therefore, no evidence could be found to support the allegation that the conduct of the President in this regard was in breach of Section 96(1) and 2b of the Constitution and Clause 2.1 of the Executive Ethics Code. Accordingly, the allegation that the President violated Section 175(1) of the Constitution when he appointed Judge President Mlambo was as acting judge of the Constitutional Court and therefore breached Section 96(1) and 2b of the Constitution and Clause 2.1b(c) of the Executive Ethics Code is not substantiated. It should be noted that upon being served with the notices in terms of Rule 41(1) of the Public Protector Rules, which basically gives the complainant an opportunity to make representations upon a finding that the allegations are not substantiated, Ms. Pasha indicated that she withdraws her complaint, whereas Mr. Shivambo MP did not respond to the notice. So in line with the Public Protector Act, the matter is closed. I move over to report number 12 of 2023-2024. During the course of June 2022, complaints were lodged with the Public Protector in respect of allegations of violation of the Executive Ethics Code against the President of the Republic of South Africa, Mr. Matamela Cyril Ramaphosa, as well as allegations of improper conduct against members of the South African Police Service in terms of the Public Protector Act. The complaints were lodged by Mr. Violetu Zungula and Mr. John Steenhuisen, who are members of the National Assembly, in terms of the Executive Members Ethics Act, as well as by Mr. Elias Miller and Mr. Simpiwe Ndlovu, who are ordinary members of the public in terms of the Public Protector Act. We received 2 written complaints dated the 2nd and the 3rd of June 2022 from Mr. Zungula in connection with allegations that the President had violated the Executive Ethics Code 2000, published by the proclamation in Government Gazette number 21399, notice number 41, regulation 6853, known as the Executive Ethics Code, in relation to the housebreaking with the intent to steal and theft of cash and foreign currency that took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province. Further to the complaint from Mr. Zungula, we subsequently received 3 more similar complaints in June 2022 from other complainants, namely Mr. Steenhuisen, Mr. Ndlovu, and Mr. Miller. All the complaints were based on the affidavit of Mr. Arthur Fraser, the former Director General of the State Security Agency, which at the time was not in the possession of the Public Protector, but was in the public domain and circulating around various media platforms, indicating, amongst other things, that Mr. Fraser had laid criminal charges against the President at the Rosebank Police Station in Gauteng. The complaints were then consolidated into one file to avoid a duplication of investigations, as the facts arose from the same incident and are mutatis mutandis. The complainants were all notified accordingly of this development. An objection was raised by Mr. Zungula to this method of dealing with the matter. The objection was premised on the notion that the consolidation of the complaints would have the effect of prolonging the investigation. In response thereto, Mr. Zungula was advised that the Public Protector Act conferred on the Public Protector the sole discretion to determine the format and procedure to be followed in conducting an investigation with due regard to the circumstances of each case, and that this position had been reiterated by the Supreme Court of Appeal. This aspect is dealt with more elaborately in the report. At this stage, it suffices to say that the investigation process was inevitably going to be informed by the provisions of Section 6 and Section 7 of the Public Protector Act, which on their own carry no inherent risk of delays into the course which the investigation pattern may follow, regardless of whether the matter is pursued under EMEA or the Public Protector Act. Furthermore, the Public Protector South Africa is on record on its presentation to Cabinet on the 24th of May 2017 that, amongst others, on the challenges faced in complying with the statutory requirements to finalize and report on a EMEA investigation within a period of 30 days due to factors such as the internal capacity constraints and the scope of the investigations, such as the one of this nature. This challenge is, however, mitigated by Section 3, Subsection 3 of EMEA, which permits the Public Protector to report to the President or the Premier in circumstances where an investigation would not be completed in 30 days. The substance of the objection to the approach to the Public Protector South Africa's reporting obligations in terms of the EMEA is informed by an interpretation of the relevant legislative framework, which is within the exclusive prerogative of the acting Public Protector in this instance. Mr. Zungula's insistence that an interim report be released on the merits of the complaint prior to the completion of the investigation was therefore deemed as contrary to the legal standards that ought to be complied with, as have been applied by all public protectors since the promulgation of EMEA. The investigation was conducted in terms of Section 182(1) of the Constitution, read with Section 3 of the EMEA, and Section 6, Subsection 4 of the Public Protector Act. It included an analysis of all relevant documentation, the application of relevant law, case law, and related prescripts. All the relevant information relied upon to reach the conclusions detailed in the report are specified in the report. The investigation looked into the conduct of a number of persons, namely the President of the Republic of South Africa, Mr. Ramaphosa, the National Commissioner of SAPS, then General Fani Sihlane Masemula, the current commissioner rather, and the former Commissioner of SAPS, General Kehla Stole, the former Special Advisor to the President, Mr. Benjani Chauke, the head of the Presidential Protection Services, Major General Wali Rweda, and an official of the Presidential Protection Services, Sergeant Shulani Rikoto. Other persons to whom the notice was delivered on the 10th of March 2023, as well as the final report being issued today, have been delivered to are the Speaker of the National Assembly, Mrs. Nosiviwe Mapisa Magula, the Minister of the South African Police Service, Mr. Bheki Cele, as well as all the complainants in the matter. With the complaint having been lodged partly by members of the National Assembly under the EMEA, there is no discretion to consider whether or not to investigate a matter, as the EMEA provisions in this regard are peremptory. The alleged improper conduct by the President involving a potential violation of the Executive Ethics Code was therefore investigated under Section 3, Subsection 1 of the EMEA. Although Mr. Ndlovu and Mr. Miller's complaints relate to the same allegations that on 9th of February 2020, there was a theft of millions of US dollars stored within the President's private residence at Phala Phala Farm, their complaints are not covered under Section 4, Subsection 1 of the EMEA. Section 4, Subsection 3 of the EMEA indicates that nothing in this section may prevent the Public Protector from investigating any complaint by a member of the public in accordance with the Public Protector Act. Mrs. Ndlovu and Miller's complaints were accordingly dealt with in terms of the Public Protector Act. The factual inquiry principally focused on whether or not the President violated the Executive Ethics Code as a result of the alleged housebreaking with the intent to steal and theft of cash in foreign currency that took place on or about the 9th of February 2020 at Phala Phala Farm, and acting in a way that is inconsistent with his office in a manner that he dealt with the alleged crime. Another part of the factual inquiry principally focused on whether the members of the South African Police Service failed to comply with and uphold their statutory and constitutional duties in relation to the events that followed the housebreaking with the intent to steal and theft of cash in foreign currency, which took place at Phala Phala Farm. The inquiry regarding what should have happened focused on the law and rules that relate to the standard that should have been met by the President to comply with the Executive Ethics Code and by the members of the SAPS to act in accordance with the standard expected in the proper performance of their constitutional and statutory duties. The inquiry regarding the remedial action seeks to explore options for redressing the consequences of the improper conduct or the maladministration. This approach included a variety of methods such as an exchange of documentation between the institution, the President, the Speaker of the National Assembly, Mr. Fraser, various state institutions, managers of Phala Phala Farm, as well as other individual witnesses who are in possession of information which has a bearing on the investigation of this matter. It is acknowledged that when the details of the Phala Phala Farm incident came to light in 2022, multiple oversight mechanisms sprang into action, sometimes working collaboratively, at times in parallel, which resulted in several institutions and oversight bodies simultaneously being seized with the investigation of the same matter in accordance with their own functions and mandates. And this includes the South African Revenue Services, the South African Reserve Bank, the Directorate of Priority Crimes Investigation, the Financial Intelligence Center, the Independent Police Investigative Directorate, the independent panel appointed by the South African Parliament in terms of Section 89 of the Constitution in October 2022. The laws and policies that inform the investigations in the above institutions are in line with the prescribed mandates. Various case law, which is cited in the report, was also considered. The analysis of the complaint led to the identification of 3 issues for the investigation. Firstly, whether the President of the Republic of South Africa, Mr. MC Ramaphosa, acted in a manner that is inconsistent with his office in dealing with the alleged housebreaking with the intent to steal and theft of cash in foreign currency that took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province, and thus abused state resources, exposed himself to any situation involving a risk of a conflict between his constitutional duties and obligations and his private interests arising from or affected by his alleged paid work in violation with Clause 2.1 B and D and Clause 2.3 D F G of the Executive Ethics Code. Whether the President failed to report the alleged crime that took place at Phala Phala Farm on or about the 9th of February 2020 and abused his power in utilizing state resources by causing the Presidential Protection Services, known as the PPS, to be deployed to Phala Phala Farm and to investigate a housebreaking with the intent to steal and theft of cash of foreign currency at Phala Phala Farm, thus violating Clause 2.3D and F of the Executive Ethics Code, and whether such conduct constitutes improper conduct as contemplated in Section 182, subsection 1 of the Constitution, and abuse of power as contemplated in Section 6, subsection 4A and Roman numeral 2 of the Public Protector Act, and whether the members of the South African Police Service, which shall hereafter be referred to as SAPS, attached to the PPS, acted improperly by investigating the alleged housebreaking with the intent to steal and theft of cash in foreign currency, which took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province, and if so, whether such conduct constitutes improper conduct as contemplated in Section 182(1)(a) of the Constitution, and maladministration as contemplated in Section 6, subsection 4A, Roman numeral 1 of the Public Protector Act. On the first issue, it's whether the President of the Republic of South Africa acted in a manner that is inconsistent with his office in dealing with the alleged housebreaking with the intent to steal and theft of cash of foreign currency that took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province, and thus exposed himself to any situation involving a risk of a conflict between his constitutional duties and obligations and his private interests arising from or affected by his alleged paid work in violation of Clause 2.1b and d and Clause 2.3d, f and g of the Executive Ethics Code. Upon analysis, it was considered that the President's response is a denial of allegations that he undertook paid work outside his cabinet duties. The President denied any breach of the Code of Ethics and Section 96, subsection 2a and b of the Constitution. He stated that he does not work for Tabanyoni or Phala Phala Farm and was not paid for anything. The concept of paid work and or remunerative work was not defined in the Constitution, EMEA, or the Code of Ethics. In order to arrive at the decision whether the President breached the Constitution and the Code of Ethics, it is pertinent to interpret and determine the meaning of the concept. I quote, undertakes any other paid work, I unquote, and or receive remuneration for any work or service other than for the performance of their functions as members of the Executive Ethics, own emphasis. The modern approach to interpretation is neatly summarized as follows by the Constitution. I quote, the interpretation of the Act must be guided by the following principles. A, words in a statute must be given their ordinary grammatical meaning unless to do so would result in an absurdity. B, this general principle is subject to the three interrelated riders. A statute must be interpreted purposively. The relevant provision must be properly contextualized, and the statute must be construed consistently with the Constitution, meaning in such a way as to preserve its constitutional validity. I unquote. In the matter of the Public Protector and others versus the President of the Republic of South Africa and others, the court stated that, I quote, the Constitution, the Members Act, and the Code exist for the purpose of enhancing and enabling the attainment of justice, giving substance to our founding values, and ensuring compliance with high ethical standards and constitutional obligations. They are not to be interpreted in a way that impedes the realization of these critical objectives. Courts should not therefore inadvertently enable schemes designed to or that could unintentionally frustrate the fulfillment of ethical imperatives and constitutional obligations by allowing legal sophistry or technicalities to obscure commonsensical realities. I unquote. Section 1 of the Basic Conditions of Employment Act states that, I quote, remuneration, I unquote, means any payment in money or in kind, or both in money and in kind, made or owing to any person in return for that person working for any other person, including the state, and remunerate has a corresponding meaning. In terms of Section 30, subsection 6A of the Companies Act 71 of 2008 as amended, I quote, remuneration includes fees paid to directors of service for services rendered by them to or on behalf of the company, including any amount paid to a person in respect of the person's acceptance of the office of director, I unquote. Section 1 of the Occupational Health and Safety Act provides that employer means, subject to the provisions of subsection 2, any person who employs or provides work for any person and remunerates that person, or expressly or tacitly undertakes to remunerate him. The OHSA also defines remuneration as any payment in money or in kind, or both in money and in kind, made or owing to any person in pursuance of such person's employment. The OHSA further defines employment or employed as meaning employment and employed as an employee. The OHSA further defines work to mean work of an employee or as a self-employed person, and for such purpose an employee is deemed to be at work during the time that he is in the course of his employment, and a self-employed person is deemed to be at work during such time as he devotes to work as a self-employed person. The Guide on Managing Other Remunerative Work in the Public Service states that to have an interest in a business is not work per se. There has to be evidence of a physical or mental effort contributing to the operations of the business over a period of time. Over a period of time means the event continues for a period of time without stopping. According to the affidavit of General Rueda, the President declined the permanent deployment of the PPS personnel and technology at the Phala Phala Farm on the basis that he is not always there. Having assessed the definition or meaning of paid work or remunerative work, it is prudent to state that applicable sources in the main refer to employees in the employ of the state rather than specifically to the members of the executive. However, for the purposes of this investigation and determining the ordinary meaning of the relevant statutory provisions, these guidelines serve as the only source of interpretation of the concept of paid work or remunerative work. In the case at hand, the meaning of the words paid work or remunerative work appear to be plain as well as in harmony with the syntax in which it occurs. The wording should therefore be interpreted in line with its ordinary grammatical meaning. Objectively viewed, these words mean that the member of cabinet must not, regardless of the form of work or agreement in place, be paid or receive remuneration in respect of any work other than work related to his or her duties as a member of cabinet. The only prohibition that rises from the scheme of Section 96, subsection 2A of the Constitution and from Clause 2.3g of the Code of Ethics is narrow and focused, and that is to say a member of cabinet may not do other work for which he or she gets paid or receives remuneration. Within this context, it is imperative that consideration be given to the purpose of the prohibition of undertaking other paid work. This is one of the most important considerations which ultimately informs whether or not there has been a violation of the provisions of the Code. That purpose can only be to ensure that members of the executive give their undivided attention to their jobs as a part of the executive and to prevent them from becoming distracted by other work that they could earn remunerative work from. In other words, their prohibition is on earning other active income in the sense that it is income earned in exchange for work or services that would distract the member concerned from fulfilling their functions in government. At the same time, when read in context, the EMEA and the Code recognize realistically that members of the executive will hold financial interests. These other interests will in most instances also produce income for the members concerned, such as rent received from immovable property owned by the member and leased out, or dividends received as a stakeholder in a listed or private company. Members are required to disclose these interests in terms of Section 2, subsection C of the Act and paragraph 5 of the Code. In the Code, there is therefore nothing per se problematic with members of the executive holding financial interests which may provide them with another source of passive income, income which they receive without having to undertake work or provide services. What is prohibited is the active involvement of members in the enterprises which produce the income, because that would divide their attention from their official duties. Very often determining this issue will be a matter of degree and the dividing line between passive, permitted involvement and active, prohibited involvement will be difficult to draw. Declaration of financial interests. While the President acknowledged that he still retains certain interests in Phala Phala Farm as a game and cattle farm operation, he submitted that he does not conduct any other paid work or in relation to the farm as envisaged in Section 96, subsection 2A of the Constitution. On the 7th of October 2022, the PPSA investigation team inspected the register of financial interest of the President, in particular for the period between 1st of April 2019 to the 21st of March 2020. The President's financial interest and members' interests held in Dabanyoni and Chivasa Trust were declared. The value and the nature thereof were also disclosed in the financial register kept in the office of the Secretary to Cabinet. On the remuneration part of the register of the financial interest of the President, it was observed that the President declared that he received no remuneration other than as a member of the Executive during the reporting period 2020 as required in terms of paragraph 5.6 of the Executive Ethics Code. The President indicated further that he instructed Mr. Stainspeed of his office to ensure compliance with the Executive Ethics Code as required by paragraph 8.1 and that he is aware of the provisions of the Executive Ethics Code regarding the proper conduct expected of the members of the Executive. The President's interests in Dabanyoni and Chivasa Trust are described as, I quote, registrable interests, I unquote, and records inspected indicated that he has declared this investment as financial interests which he has in corporate entities. In terms of paragraph 6 of the Code of Ethics, financial interests refer to registrable interests that must be disclosed, such as shares of other financial interests in companies and other corporate entities, sponsorships, gifts and hospitalities other than that received from a spouse or permanent companion or family member, benefits, foreign travel other than personal visits paid for by the member or official travel paid for by the state, travel paid for by the member's party, land and immovable property, including land or property outside South Africa, and pensions. No evidence could be found indicating that the President either works at Phala Phala Farm or receives remuneration from Phala Phala Farm. The Executive Ethics Code creates a distinction between the concept of paid work or remuneration as contemplated in paragraph 2.3g of the Code of Ethics and financial interests as described in paragraph 6 of the Code of Ethics. The objectives of this distinction in the Code of Ethics is to separate the paid work remuneration as envisaged in an employer-employee relationship as opposed to shares or other financial interests in companies and other corporate entities. The purpose of this distinction is clear, namely to avoid a risk of competing demands on the time required for public responsibilities, undue influence on political behavior, and conflict between the constitutional duties. Evidence arising from the inspection of the President's Register for Financial Interest reveals that the President retains financial interest in Dabanyoni, as described in paragraph 6 of the Code of Ethics. While not conclusive, these facts certainly point towards the President being more actively involved in the management of the affairs of the close corporation than he appears to let on in his general submissions. There are, of course, other facts which point away from the President being involved in paid work. For one thing, he neither draws a salary from the Dabanyoni CC, nor receives any distributions, only the payment of a soft loan. He evidently is not often physically present at the farm. Looking into the risk of a conflict of interest, paragraph 2.3f of the Executive Ethics Code and section 96, subsection 2b of the Constitution stipulate that members of the executive may not expose themselves to any situation involving the risk of a conflict between their official responsibilities and their private interests. The aim of these provisions is to prohibit conduct that is inconsistent with a member's office, or that which exposes a member to any situation involving the risk of a conflict between his or her official responsibilities and private interests. A conflict of interest is a situation in which a person has a duty to more than one person or organizations, but cannot do justice to the actual or potential adverse interests of both parties. According to the King 4 report on corporate governance in South Africa of 2016, a conflict of interest used in relation to members of the governing body and its committees occur when there is a direct and indirect conflict, in fact or in appearance, between the interest of such member and that of the organization. It applies to financial, economic, or other interests in any opportunity from which the organization may benefit, as well as use of the property of the organization, including information. The Organization for Economic Cooperation and Development, known as the OECD, is a unique forum where governments of various democracies work together to address the economic, social, and environmental challenges of globalization. South Africa is a key member state to the OECD, having joined on the 16th of May 2007. The OECD is also at the forefront of the efforts to understand and help governments respond to new developments and concerns such as corporate governance, managing conflict of interest, and to seek answers to common problems, identifying good practice, and work to coordinate domestic and international policies. In its report or toolkit titled, I quote, Managing Conflict of Interest in the Public Sector, I unquote, emphasis is placed on the pressing need to properly manage perceived or potential conflict of interest and provides inter alia, I quote, a conflict of interest is not necessarily corruption, which is understood as actual abuse of public office for private advantage, but a conflict does have the potential for corruption conduct. Conflicts between private interests and public duties of public officials must therefore be correctly identified, appropriately managed, and effectively resolved. Left unresolved, a conflict of interest can result in corrupt conduct, abuse of public office, misconduct, breach of trust, or unlawful action. More important, public confidence in the integrity of the public institutions can also be seriously damaged, I unquote. A conflict of interest is not in itself misconduct. However, failing to recognize it or manage it appropriately is at best improper. The private interest of an official assumes a public dimension only if and when it impinges on or is perceived to impinge on some action or decision the official must take in the course of duty. If this occurs, the official becomes conflicted and must promptly consider the proper ethical path to take in the particular case. In the Western Cape High Court, the court held the test regarding a conflict of interest, I quote, rests upon the broad doctrine that a man who stands in a position of trust towards another cannot in matters affected by that position advance his own interest by making a profit at that other's expense, I unquote. There are many different views on the definition of a conflict of interest. However, the common scheme presents in all definitions relates to a clash between the official and business duties of the decision maker concerned and his or her personal interests. The official or business interests are often described as the primary interests, while the personal interests are regarded as secondary interests. Primary interests refer to the principal goals of the profession or activity and duties of the public office. Secondary interests include not only financial gain, but also such motives as the desire for professional advancement and the wish to do favors for family and friends. But conflict of interest rules usually focus on financial relationships because they are relatively more objective, fungible, and quantifiable. Again, paragraph 3 of the code makes it clear that not all interests held by a member of the executive will give rise to a conflict for purpose of the code. The existence of a secondary interest is therefore not treated as wrong in itself, but becomes objectionable when believed to have greater weight than the primary interests. The conflict in a conflict of interest exists whether or not a particular individual is actually influenced by the secondary interest. It exists if the circumstances are reasonably believed on the basis of past experience and objective evidence to create a risk that decisions may be unduly influenced by secondary interests. Again, as this provision makes clear, not all interests held by a member of the executive will give rise to a conflict for purposes of the code. This is clear when regard is had to paragraph 3.6, which requires a member to disclose of an interest in a company or corporate entity or profit-making enterprise, or place it in the management of an independent person if that interest may give rise to a conflict of interest in the performance of that member's function as a member of the executive. The President contended that he had been advised that the kind of interest he retains in Phala Phala Farm as a game farm and cattle farming operation does not give rise to a conflict of interest or expose him to any situation involving the risk of a conflict between his official responsibilities and his private interests. He retains assets which he believed would not give rise to a conflict of interest, including his members' interest in the CC that operates Phala Phala. He also remains both a trustee and beneficiary of the Chibase Trust, which owns the farm property. In the abstract, ownership of a farm or corporate entity that runs a business on a farm is very unlikely to give rise to a conflict of interest in the performance of a member's functions as a member of the executive. In terms of the evidence placed before the public protector, the day-to-day operations of Phala Phala Wildlife are managed by Mr. von Velach as the general manager with the assistance of about 40 employees. Though occasionally when the President visits the farm, they would seek evidence from him, from him, and he would give guidance. The buffalo sales transaction between Mr. Ndlovu and Mr. Hazim took place in the absence of the President, thus indicating that he is not involved in the ordinary business decision-making largely. The evidence revealed that the President held discussions with farm managers, notably regarding the disposal of certain animals due to them being substandard. Considering the evidence in its entirety and the application of the law, there is no basis to exalt such deliberations to a degree where it can be held that there existed a real or potential conflict of interest on the part of the President regarding his duty as the head of cabinet and his interest in the game cattle farming at Phala Phala Farm in violation of the code. Thus, no evidence could be found to underpin a finding or a conclusion that the President's comments or utterances in the regard were a continuous act to be considered or construed as active involvement in the business or paid work. Aggregated against the standard imposed by the Executive Ethics Code, it is found that there is no basis upon which to conclude that the President contravened Clause 2.1b, D, Clause 2.3d, F and G of the Executive Ethics Code, including the period following the alleged theft of the US dollars that took place on or about 9 February 2020 from his private house at Phala Phala Farm in Waterberg, Limpopo. Therefore, the evidence does not support the allegation that the President's financial interest in game or cattle farming at Phala Phala Farm exposes him to any situation involving the risk of a conflict between his official responsibilities and his private interests. Accordingly, the allegation that the President improperly and in violation of the provisions of the Executive Code exposed him to any risk of a conflict between his constitutional duties and obligations and his private interests arising from or affected by his alleged paid work at Phala Phala Farm is not substantiated. Moving over to the second issue, evidence indicates that Phala Phala Farm was not listed as the President's private residence on which there was a full-time deployment of the PPS personnel at the time of the crime of the housebreaking with the intent to steal and theft, because the president chose not to have it listed as he seldom visits the farm. This, according to the president, was intended to mitigate the use of state resources. According to General Rueda, since his appointment on the 1st of June 2018, he attempted to persuade the president that PPS personnel should be deployed at the farm, as the president visits as one of his private residences. General Rueda stated that when the president was not at the farm, there were no SAPS or PPS members to prevent breaches of security. General Rueda further indicated that the president has always refused the deployment of PPS personnel and technology at the farm. Having regard to the applicable prescripts, notwithstanding the president's initial refusal to have PPS deployed at Phala Phala Farm, paragraph 12 of the presidential handbook, read together with the PPS policy, prescripts that the SAPS must take full responsibility for the protection and security of the president at all times during his term of office. These prescripts stipulate further that protection and security measures of the president include, inter alia, regular security assessment in conjunction with intelligence agencies and static protection at all official and private residences, and office accommodation used from time to time during his term of office. According to evidence of General Rueda, Mr. Ndlovu, and Mr. von Velaf, and the President on the 10th of February 2020, there was a security breach by intruders at Phala Phala Farm, which the President reported to General Rueda on the same day. Thereafter, Mr. Ndlovu reported to the President that the money from the sale of game was stolen from the President's residence at Phala Phala Farm. After confirming same on the 2nd of March 2020, the President reported that the theft of money from the sale of game to General Rueda. Having considered the response of Mr. Zungula, the contention that the President was the only person as a member of the close corporation to report a crime as directed by Section 34(1) of PRECA is not supported by a proper reading of the relevant section, and that both Mrs. von Velaf and Mr. Ndlovu too were persons of authority mandated to report the theft as envisaged in sections 34(4)(e) and Roman figure 1 of PRECA, and had an obligation as persons with the personal knowledge of the crime to report the housebreaking. Section 34 subsection 1(e) and numeric 1 of PRECA places the duty on certain persons to report certain offenses. Failure to report is an offense. In this case, the public protector is not empowered to pronounce on the merits and demerits of the alleged crime and to make findings in respect thereof, because the offense does not fall within Section 6 subsection 4(a) of the Public Protector Act. The matter is being investigated by the public body which is tasked with criminal investigations, namely the DPCI. In a letter dated 26 April 2023, General Masemula confirmed to the investigation team that on the 22nd of August 2022, Mr. von Velach opened a case, namely Bila Case 29908 of 2022, for housebreaking and theft that took place on the 9th of February 2020. In considering Mr. Steenhuisen's submission for the public protector to reject the notion and evidence that the President did not instruct, consent to, or otherwise know of the unlawful investigations by members of the SAPS, the public protector heeded the advice of the Constitutional Court that where evidence is inconclusive or incongruent, the institution is obliged to carefully evaluate it to determine the truth. This decision affirms the objective of investigations by the public protector is to discover the truth. Where the investigation yields disparate pieces of evidence which do not fit into place, the public protector must continue digging until the true picture emerges. The court further noted that when the versions placed before the public protector diversion on same of the issues, she should not, without more evidence, prefer one version over the other. I quote, "The truth is established by facts and not by one's preference," I unquote. The Constitutional Court furthermore warned that the public protector has no place summarily dismissing any information. His or her function is to weigh the importance or otherwise of the information and, if appropriate, to take steps that are necessary to determine the truth. To this end, and having identified witnesses who were interviewed and approached for information and their testimony, this report sets out in detailed form the evidence of each witness. These include the president, the managers of Phala Phala Farm, as well as the members of the SAPS involved. The evidence was obtained by means of a proactive and systemic investigative process and was thoroughly scrutinized. The substantive evidence and information at the disposal of the public protector is corroborative of each other on all relevant issues and cannot, on a balance of probabilities, be construed or perceived as inconclusive or congruent or summarily dismissed. Determination of the origin and exact amount of the money stolen from Phala Phala Farm was not within the scope of the investigation of the public protector. It is therefore incorrect to summarize that the public protector seems to be satisfied with the quantity or origin of the foreign currency stolen. The focus of the investigation was only on the three distinct identified issues in the report. The concept of abuse of power is not defined in the Public Protector Act. However, in terms of the dictionary meaning, it is defined as wrongful use of the position of authority to influence employees, students, colleagues, or volunteers, coercion to participate in activities or decision-making in violation of laws, regulations, or policies. In the matter of Gigaba versus the Minister of Police and others, Saduala J. gave an example of abuse of power as an instance in which powers given to the public authorities to be used for certain purposes are wrongly used by them to achieve another unauthorized ulterior purpose. In this case, the court held that the involvement of the Hawks or the DPCI in the trivial domestic split amounted to the abuse of power by Mr. Gigaba as the former minister in using the state administration for his own personal benefit for the intention to intimidate the applicant. In determining this issue, evidence was evaluated to establish if the conduct of the president can be equated to an abuse of his position of power and whether he utilized state resources, which included deployment of PPS members to Phala Phala Farm and to investigate the crime of housebreaking with the intent to steal and theft without a registered case to recover the stolen money. In response to the notice, Mr. Steenhuisen stated that the president consented to or knew of the use of PPS resources beyond its mandate. Mr. Steenhuisen insisted that the president acquiesced either or actively or passively in the abuse of power and PPS resources. Mr. Steenhuisen did not furnish any evidence to support this contention. No evidence could be found to prove that the president was aware of the investigation of the crime by General Roda. As a result, a finding cannot be made that assumes a position with respect to the president's state of mind without empirical evidence to support the allegation that he consented to the use of PPS resources beyond their mandate or for an ulterior purpose. Regarding the third issue, on the 20th of October 2022, Sergeant Rikoto stated on record during the interview with the investigation team that while he and General Roda interviewed Mr. David Joseph at Phala Phala Farm, Mr. Joseph admitted that he arranged with his Namibian friends from Cape Town, who subsequently broke into the president's private residence at Phala Phala Farm and stole cash in US dollars. According to Sergeant Rukhoto, Mr. Joseph was given a share of 30,000 rand, and he was angry that he was not given enough money for his role. The interviews conducted with suspects at Phala Phala Farm in March 2020 were also confirmed to the investigation team by General Rhoda himself on record. It was further revealed by General Rhoda in paragraphs 2 and 4 of his supplementary affidavit dated the 1st of September 2022 that when he interviewed Mr. Joseph in March 2020, he read his constitutional rights to him. These rights are understood to be read to a person who is being arrested, detained or accused in terms of Section 35 of the Constitution. The act of reading these rights to Mr. Joseph is indicative of an interaction between a police officer conducting a criminal investigation and a suspect. The information disclosed to both Sergeant Rukhoto and General Rhoda by Mr. Joseph during the interview held on the 3rd and the 4th of March 2020 places a legal duty on them as police officers in terms of Section 13, subsection 2, subsection 3 of the SAPS Act to report to the commanding officer or to perform such duty in a manner that is reasonable under the circumstances. It is tried and a settled fact that housebreaking with the intent to steal and theft is a common law offense in South Africa. The Supreme Court of Appeal in the matter between the state versus Bakane and others in paragraph 30 held that a rigid interpretation of Section 13, subsection 2 of the SAPS Act that may amount to an interpretation that a member of the SAPS has no legal reporting duty to report other crimes that are not created in regulations such as the shooting incident in question. It is a brazen perversion of the section which cannot be countenanced, least from law enforcement officers. I unquote. The court stated that this duty flows from Section 205, subsection 3 of the Constitution and is affirmed by the SAPS Act. Therefore, General Rhoda and Sergeant Rukhoto were legally obliged to act in line with the provisions of Section 13, subsection 2 and subsection 3 of the SAPS Act upon becoming aware of a crime, namely a common law offense of housebreaking with the intent to steal and theft, that it had been committed, and more so when suspects made admissions to them during an interview in respect of the same crime or offense. According to the evidence, General Rhoda reported this incident to General Mfazi, who was neither his commanding officer nor part of the DPCI as contemplated in Section 34 of PRECA. General Rhoda indicated during his interview that the investigating team that he opted to report this matter to General Mfazi, who is since late as the head of crime detection services, and also because the National Commissioner was busy with performance assessments. General Rhoda further stated that another reason for reporting to General Mfazi was that their officers were in the same corridor. However, in terms of the SAPS approved national and provincial organizational structure for 2020-2021 financial year, General Rhoda, as the component head of the PPS, reports directly to the National Commissioner of the SAPS. Evidence further indicates that General Rhoda conducted an investigation assisted by Sergeants Rukhoto, Mr. Trevor Fredericks, and Nick to investigate this incident without a case having been registered on SAPS CAS. It is important to note that although Mr. Fredericks and Nick assisted General Rhoda to conduct his investigations, they were not members of the SAPS. The evidence and objectively ascertainable facts around the activities of General Rhoda, Sergeant Rukhoto, and Nick do not support the assertion that these were primarily aimed at conducting a threat analysis or assessment in respect of the President or his private residence at Phala Phala Farm in accordance with the applicable legislative framework. It is noted from the following statement by General Rhoda, which confirms the investigation of crime, the tracing and following of money stolen from Phala Phala Farm as contained in his supplementary affidavit. I quote, "When I was in Cape Town around the 10th or 11th of March 2020, I received a call from Sergeant Rikoto, who told me that he had found out from certain sources that the perpetrators of theft had bought new cars. He said that the cars had been bought from Barons in Kallenberg, Cape Town. Shortly after receiving the call, from Sergeant Rikoto, he picked me up at my office in Gama House opposite Parliament. We drove to Barron's Motors and spoke to the manager, who confirmed that on the 14th of February 2020, a Mr. Mukekeni had purchased a 2019 Ford Ranger and supplied further details in relation to the purchase of the vehicle. I unquote. The above extract from General Rueda's supplementary affidavit is corroborated by the affidavit of Mr. Mali, who was the car sales manager at Barron's in Colombo, Cape Town, which indicates that the police officer requested details of the sale transaction identified and residential address of the buyer. Furthermore, the report compiled by Sergeant Rikoto only addresses issues related to the crime of the housebreaking with the intent to steal and theft at Phala Phala Farm. The report by Sergeant Rikoto is clearly tabulated into three distinct headings which focus on crime as follows. A. Role players in the planning and commission of crime. B. Background of what transpired until the commission of crime. And C. Surveillance and gathering of information of individuals connected therewith. It is noted that the report by Sergeant Rikoto specifies its subject, the role played by each during the commission of the crime, and what was bought with the money they stole from Phala Phala Farm. This report by Sergeant Rikoto does not make any remarks, conclusions, and findings about any threat or risk assessment to the personal safety of the President or his family. While Sergeant Rikoto, in his response to the notice, contains that he was merely acting on the instruction of his supervisors or superiors, it is a tried principle of law that employees are not under any obligation to obey unlawful or illegal instructions. Employers, including SAPS, have developed job descriptions in order to assign certain tasks to certain units or employees in order to promote efficiency and accountability. In the circumstances, a job description should have guided Sergeant Rikoto's refusal to perform the certain duties or tasks if he believed it fell outside the scope of his job description. In the matter of the City of Cape Town versus Nkomo and others, the Labour Code confirmed that the employees are not obliged to obey to unlawful instructions. In light of the above, the refusal to obey to an instructions to do work that was unlawful or that Sergeant Rikoto legitimately felt he was not qualified to perform could not have been held to constitute insubordination. The fact that Sergeant Rikoto acted on his superior's instructions, who is General Rueda, could not by itself have justified his conduct to obey unlawful instructions. An employee is under no obligation to obey an unlawful instruction. If he obeys an unlawful instruction, he does so at his own risk. Further observations are made. It is noted that Mr. Chauke, who is neither in the employ of the SAPS nor covered by the REMIS policy, traveled to Namibia on the 25th and 26th June 2020, accompanied by General Rueda using PPS resources with the approval of General Sithole. The request for the trip approval was signed and submitted by General Rueda on the 24th of June 2020, and it is clear from paragraph 1 of the memorandum seeking approval of the trip that General Rueda would be accompanying Mr. Chauke to Namibia from the 25th of June 2020 to the 26th of June 2020. However, in terms of the evidence, no link or nexus could be established between the trip to Namibia and the investigation that was conducted by the PPS in respect of the crime of housebreaking with the intent to steal and theft committed at the Phala Phala Farm on the 9th of February 2020. The Public Protector is empowered in terms of Section 182(1)(c) of the Constitution to take appropriate remedial action with the view of redressing the conduct highlighted in this report where adverse findings are made. With due regard to the evidence, the regulatory framework determining the standard that members of the PPS, namely General Rueda and Sergeant Rikoto, should have complied with, hereby the following remedial action in terms of section 182(1)(c) of the Constitution is taken. The Minister of the South African Police Service must take note of the findings of maladministration and improper conduct against the SAPS as highlighted in this report in connection with the allegation that the members of the SAPS attached to the PPS acted improperly by investigating the crime of housebreaking with the intent to steal and theft, which took place on or about the 9th of February 2020 at Phala Phala Farm, in line with the authority vested on the Minister of Police in terms of Section 206 of the Constitution. The National Commissioner of SAPS must, within 60 calendar days from the date of receipt of this report, ensure that appropriate action is initiated against General Roeder and Sergeant Ricotta for contraventions of the SAPS prescripts as highlighted in this report, in line with the provisions of Section 40 of the SAPS Act and Regulation 6 of the SAPS Discipline Regulations 2016. Must, within 90 calendar days from the date of receipt of this report, develop an appropriate PPS directive, instruction, policy or such other prescripts within the statutory powers vested in the National Commissioner in terms of Section 11 of the SAPS Act and Section 207 subsection 2 of the Constitution, directing how the PPS members must manage crimes reported directly to them by the VIPs under their protection. For monitoring by the Public Protector, the SAPS are to provide a report to the Public Protector on the implementation of the remedial action within 60 calendar days from the date of this report. The importance of the implementation of the Public Protector's remedial action is no better evidence than through the amazing work of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, which is a product of the remedial action of the Public Protector South Africa. Given the magnitude of the commitment and efforts that have gone into the work of the Zondo Commission, the Commission's findings would be the logical starting point for any retrospective understanding of the existence, nature, and extent of the state capture or prospective remedial measures to prevent a recurrence. The Commission's findings on the mechanisms and causes of state capture, and in particular institutional weaknesses in the state, provide a strong foundation for implementing crucial reforms. Ethical leadership in the public sector, including the government agencies and SOEs affected or involved in state capture, is a critical foundation to curb corruption and ensure good governance. Leadership should be participatory, consensus-oriented, accountable, transparent, responsive, effective and efficient, equitable and inclusive, and follow the rule of law. This could ensure that corruption is minimized, the views of communities are taken into account, and the voices of the most vulnerable in society are heard in decision making. For the Public Protector, this journey is, however, far from over. As stated in the report, we will continue to monitor the remedial action. At this juncture, I take this opportunity to confirm that we have received Parliament's progress report as of 26 June 2023 on their implementation plan of the remedial action stemming from the state of capture report as well as the progress. These reports are expected to provide progress on the President's broad commitment to reforms in the areas of whistleblower protection and incentivization, procurement reform, and capacitation and strengthening of laws and law enforcement and other accountability institutions such as ours, the professionalization of the public administration, and the protection of public institutions from abuse. We confirm that Parliament has advised inter alia that the National Assembly has requested the Minister of Justice and Correctional Services to investigate possible shortcomings in the legal framework regulating the ethical conduct of applicable to executive members, including specific aspects of the remedial action in paragraphs 8.9 of the State of Capture report as it relates to the Executive Members Ethics Act 1998 that may require legislative amendments, and to introduce these to Parliament as a matter of urgency. As for the transversal code of conduct of all members of the state, the Department of Public Service and Administration indicates that the code was actually revised extensively in 2016. Currently, the Public Service Regulations of 2016 of the Public Service Act 1994 are being updated to bring them in line with the Public Administration Management Act of 2014. Coupled with the amendments to the Public Protector Act that we have submitted to the Minister of Justice and Correctional Services on the 5th of June this year, we are confident that the work of the Public Protector will soon, more than ever before, produce its intended purpose of truly being a vanguard of the South Africa's constitutional democracy. Once again, on behalf of the Public Protector team, I express my sincerest gratitude to the members of the media for making it possible for us to share our work with the nation, the continent, and indeed the world. We also extend our thanks to the various departments that have cooperated with the Public Protector during our investigations. We are thankful to the people of South Africa for your patience in allowing us to complete our work, particularly in the Phala Phala report, and to all those watching and listening through this media streaming for taking the time to witness our work. But also let me take the time to acknowledge the investigators who did the Phala Phala report. Mr. Khulile Mtiki, Mr. Vusumuzi Dlamini, led by the Acting Chief Operations Officer, Advocate Nelisiwe Nkabinde, and also the work done by the Chief Executive Officer to quality assure the report and assist me in its completion. The courage that you have shown throughout this work, the resistance that you have shown throughout this work, it is indeed what was envisaged by the Constitution, that the Public Protector shall perform its duties and carry out its mandate impartially, independently, without any fear, favor, or prejudice. I also wish to thank all the executives for the role that they have played in the quality assurance of this matter. I would like to thank the team across the country for the valiant efforts that they have put into holding the name of the Public Protector up high and continue to work, and for this quarter for having produced the reports that they have produced in service of the people of South Africa. I thank you.
Thank you very much, Advocate Taleka. I'm going to take this opportunity to open the floor for a round of questions. We could be reminded to just introduce ourselves and media house we come from. There is a microphone that's going to go around for those who are a little further in the back. So, can I see your hands?
I'm not there.
1, 2, 3. Got 3. Confirm.
Thank you, Advocate. My name is Situ Moston. I'm a Sunday Ward. I'll be very quick. My first question is the date of 13 June 2020. Did it ever arise during your investigation? And the reason why I'm asking is because you found that there is no connection between the trip to Namibia where the bodyguard of the president and the advisor were there. And to me, the suspects were arrested in Namibia on 13 June 2020, which is a matter of public record. And 12 days later, the president's advisor was in the Namibian territory. The people who stole from the president were in the Namibian territory. And the president's head bodyguard was in the Namibian territory. What sort of nexus are you looking at? What sort of connection are you looking at that is not satisfied by this reality? And then my last question, your preliminary report, according to those who saw it, there was an argument on whether the money had been declared within 30 days. I could go in detail, but the argument suggests that you were satisfied that on the 30th day, when the money was supposed to be declared to the Reserve Bank, it was stolen. Therefore, the president no longer had any duty to declare. But now you're saying those matters should be left to other authorities, and you mentioned the issue of resources. It does not make sense to me, because at the time you issued the preliminary report, you had already used resources. So what resources are you saving when you already have a preliminary report? It comes across to me that this is some sort of a climb down. My inference, is it something where you feel like your initial argument was indefensible on the matter? The same on the issue of whether the president had to report. Those who saw the preliminary report said you were satisfied that he reported to Major General Rode, and he's a cop, therefore the matter was reported to the cops. And now you are then saying, no, this thing will be dealt with by the cops, whether or not there was a report and there was a case. Is this a climb down for you? Did you find after the submissions that were made by the complainants that you could not defend those positions? Thanks.
Thank you very much. My name is Yanda Ngobo. I work for Newsroom Africa. My question is also related to my colleagues regarding the Reserve Bank. You have indicated that you didn't conduct a parallel investigation, but you would have interacted with entities like SARS, the South African Reserve Bank, as well as others. So did the South African Reserve Bank confirm to you that the currency was declared within 30 days? And if that was not part of the conversation, why not? And with regards to Mr. Bejane Chauke's visit to Namibia, when he was still the special advisor, were his bank accounts within your purview? Did you speak to him regarding whether there was any money? Because we know that if you're an envoy, there's also certain protections. I stand to be corrected. So how can you possibly conclude that the trip by Mr. Bejane Chauke was only for his duties as on behalf of the president, and not also to deal with the other issue related to the theft of money at Phala Phala? Thank you.
So while you move over, can we try to keep it to one question? I'm going to have more than one round, just so that we've got an opportunity to take notes. And then we'll have a second round after. Thank you.
All right. Good afternoon, advocate. My name is Moluko from EMEA. I just want to understand, because my understanding is that the president is the sole director of Ndabanyoni Close Corporate Company, the company that is trading there by Phala Phala. These millions of money were going to be benefited actually that particular close corporate company, which the president is the sole director of now. I understand that the president to declare in the financial register that I think is held by the Secretary to Cabinet. Do you know if, as much as the president was not an employee of Phala Phala and could not have received a remunerated salary, but in terms of him benefiting or his company benefiting these millions of rand, do you know that in that financial year, the president declared this money, specifically this money, into the financial register of Cabinet? I still have more questions, by the way.
Perhaps we'll have another round.
Okay.
Okay. Any more?
Yeah. It's hard when you say we must do one question at a time. We'll be stuck here the entire day doing endless rounds. I just want to have one shot, a few questions, and then I'm done. Is that okay? Sorry, thank you for allowing me. My name is Tigi Madia. I'm with the Eyewitness News. Just a few questions. One almost riding on Zianda's one. The issue of the other institutions who are carrying out simultaneous investigations. Why not wait? You've waited this long. It's a drawn-out investigation. You have stood by, even against pressure, to release the report. Why not wait for the others to conclude? Because they might influence the overall outcome, would they not? That's the first question. Secondly, how much of this report was Advocate Musum Kwebane versus how much of it was Advocate Kalega, in that she had started the investigation, so where did you pick it up from? I know she sent out questions. And then with regards to the president's submissions, in terms of what was asked of him, did you go back, and if you didn't, I want to know why, after getting access to the affidavit? Because from what I understand, you did not initially have access to the affidavit from that criminal complaint that was laid by Mr. Arthur Fraser. I had one more, just a very quick one. Was all the evidence just based on hearsay? Because that's been the rumor that what you're dealing with is just purely hearsay. What else did you get? I imagine you did interview Mr. Fraser. What else did you get? And was it consistent with what we've been hearing in the public domain? Thank you.
I think that's it's just one point to clarify.
I'll read it out. I hope I'm loud enough. It's from Brian Sokotu from the Citizen. He's asking, is there any evidence that the president received no money from the Phala Phala game farm? Brian Sokotu from Citizen. Thank you.
Thank you for your questions. I'm going to allow Mr. Vusumu Zidlamini to answer questions and to be assisted by Advocate Kabinde.
We are live on. Okay, good afternoon, and thank you, Acting Public Protector. You will remind me with regard to some of the questions I've been jotting down as and when they were raised, but where it appears that I might not have captured the question, I will seek your assistance. Yeah, the first question from Sunday World is that on the 18th of June, the trip was taken to Namibia, whereas the suspect had already been arrested that side of Namibia. So the question is the public protector, why is the public protector not in a position to draw a nexus between the trip to Namibia and the date on which the suspects were arrested on the Namibian side? Yeah, so that question can be tackled in the following way. During the course of the investigation, we were able to establish that the purpose of the trip to Namibia was purely based on a security matter, which involved one of the countries in the SADC region. That evidence we were able to gather from the documents such as the memorandum as well as the itinerary of the trips from the office of the National Commissioner of the South African Police Service. And we're also able to gather another evidence in an effort to establish if indeed there could be a nexus or a link between this trip to Namibia and the crime that took place in Phala Phala. From the evidence that we received from the members of the SAPS that is based in the Interpol offices, I think that will be Colonel Edward, and another member of the SAPS who is based in Namibian embassy as an attaché, as a South African attaché in the embassy that side. From their submission, it was also clear that the suspect that was arrested on the Namibian side was arrested solely for the purpose of illegal border crossing, and there was no mention or any link between the purpose on which he was arrested on that side with the crime of housebreaking and theft that took place in Phala Phala on the 9th of February 2020. So on those bases, we were not able to draw any link or nexus between the trip that was undertaken by Mr. Chauke to Namibia and the suspect that was arrested. The suspect was also further profiling of the suspect, and from all of that, there was nothing for us to draw any parallels between the arrest of the suspect and the crime that took place at Phala Phala. Furthermore, from our interview with Mr. Chauke, still in an effort to probe and establish the purpose of he was also corroborated by one Mr. Titi from the State Security, who filed a confirmatory affidavit to confirm that indeed he also was aware of that trip as communicated to him by Mr. Chauke, and it was a security-related trip which Mr. Peran Chauke had to take on his capacity as the special advisor to the president and presidential envoy to Africa. We could not probe further as to the nature of the security issue that was involved, because then that would have been a confidential issue. I hope that addresses the first question. I think there was a second question which said the preliminary report, according to the preliminary report, the public protector concluded that he had no duty to, the president had no duty to declare the theft of money at Phala Phala, but now they changes on the final report and is placing the obligation on other institutions. I'm not sure if this was the case in our preliminary report, where we said the president had no duty to declare. As far as I know, we indicated that from the evidence at our disposal, the president did declare, the president did actually report both the security breach as well as the theft of money to Major General Rute, who indeed is a senior member of the South African Police Service. I can't recall a part of our report where we said the president had no duty to report, but yeah. And I think it's still the case even now. We still, from the facts revealed by the investigation, the president did indeed, after being notified that there has been a security breach at his private residence in Phala Phala, he duly reported the same to Major General Rute, who is the head of presidential protection, and subsequently also reported the crime of theft. So I think there was also a question from Newsroom Africa. Did South African Reserve Bank confirm that the currency was declared? Yes, we did approach the South African Reserve Bank with a view to get a confirmation if they assist with the investigation in line with their mandate exchange Currency Act, and they confirmed to the public protector that indeed, as the South African Reserve Bank, they are charged with the responsibility in terms of the regulations of the Exchange Currency Act to investigate any violations of foreign currency. But they could not provide us with the report or the conclusion of their investigation because they indicated that they are still busy with the investigation, and it's a matter that falls within their domain. They will report about the same as and when they are done with the investigation. So on that note, we also advise that the South African Reserve Bank should be given an opportunity to finalize their investigation and be able to report on their findings. Yeah, I think there was also the question on whether the bank records of Mr. Bechane Chauke were checked in order for us to conclude that on his trip from Namibia, he came back with money or whatever. I'm not sure if I'm capturing the question correctly. Yeah, no. On that question, Mr. Chauke is a private person, and there was no basis for us to even take that route, since there was no issue of public money also being involved. You shall remember that the money that was stolen from, or allegedly stolen from Phala Phala, is the money. It's not actually public money. So we had to also heed the advice of the court in this regard from the matter of President versus the public protector, otherwise known as the CR17 judgment, where the public protector was cautioned against probing into bank accounts of private persons and individuals, especially under the circumstances where we were not even pursuing public money. And as we may all know, that in this instance, the money involved here is not necessarily public money, so it would have been outside the remit of the mandate of the public protector. And then I think the next question was on the ENCA, whether the president put this money into the financial register for the financial year of I think 2020. Yes, you will notice when you finally get a chance to navigate through the report that the investigation team did visit the presidency, and in particular the office of the Secretary to Cabinet, and we inspected the financial register of the president. And after checking the remuneration section of that financial register, we were satisfied that the president has duly declared or rather made his declaration as required by the relevant sections of the register. And we noted that he indicated that in that part he received no remuneration other than remuneration as a member of the cabinet. Then I think the last question was from Eyewitness News, to say why did the public protector wait? Because basically to say that the public protector has waited.
She's waited so long. I want to continue waiting, but I'm just so that she can take every outcome. Like now, you've gone to the SAPS.
It's the Office of the Public Protector, other than what is contained on the affidavit of Mr. Arthur Fraser. For example, I think of interest will be to note that other than the housebreaking that took place at Phala Phala Farm on the 9th of February 2020, there was actually another housebreaking that took place the previous night on the farm, which is neighboring Phala Phala. I think the farm is called Stockist Drive. We have established that from some of the information which has been circulating on the media, some of the videos or some of the pictures purporting to be or to depict Phala Phala are in fact depicting the incidents that happened at the farm neighboring Phala Phala, because it appears that the suspects, before they actually broke into Phala Phala, they first broke into the neighboring farm, maybe probably out of incorrect or wrong information, before they came the following day and broke into Phala Phala. But we noted, we were able to establish that some of the videos and the photos that were annexed to the affidavit of Mr. Arthur Fraser did not actually reflect Phala Phala, but the farm neighboring Phala Phala. But when you also get a chance to navigate the report, like I'm saying, you will be able to establish a lot of information and the evidence that we have established, other than what is out there in the public domain or circulating in the media. Thank you.
Nelly, would you want to make some inputs?
No, at this stage I'm covered. Thank you.
CEO, inputs?
And I think I'm covered.
Okay, thank you. I think it's important today that I answer your question on why we didn't wait further. At this stage, we're not sure how far these investigations were going to take, and how long they were going to take, and how far they are at this moment. And nothing then precludes us, once they are completed, whenever they are completed, and should they found that there's a transgression, for those matters to then be investigated. But we felt that it is prudent that at this stage we release our report as far as we have done the work in terms of our mandate. I just want to add further on the travel to Namibia, that why can't we then say that there is an access, because the suspect was arrested on the 13th and they traveled on the 25th. The mere fact that the suspect was arrested on the 13th is not a confirmation that their travel was on the basis of that. And if part of the complaint is that they were to influence the arrest of the suspect, and if the suspect was already arrested, how do we then come and say they then traveled for that particular purpose to Namibia? So we really could not find that there is a nexus in that. And further, I just want to emphasize on the report that there needs to be substantial fact and evidence for the public protector to conclusively make a decision or make a finding, particularly because our remedial action is binding once we have made that particular finding. So it can't be just on the basis of what one perceives or what one thinks could have happened. Regarding Stone, the matter that we concluded that the president declared within 30 days, my recollection is that it was actually the president's version. So we did not make such a finding in the report. We couldn't have made such a finding because we do not have the report of the South African Reserve Bank. At the time when we concluded the Section 7-9, even at this stage, we do not have that report. A final report is seldom the same as a preliminary report. The preliminary report says very clearly the public protector is about to conclude the investigations. The investigations are not concluded. Therefore, by the responses that are provided by all parties involved, the public protector would then take those responses, evaluate them, investigate further on that basis, consider and carefully assess that information and evidence, and then having applied its mind and show that it has applied its mind, then come up with a final report. The fact that our final report is not precisely the same as the preliminary report, we submit that it shows that we carefully evaluated the responses that were provided to us. We assessed same, we continued to investigate and looked carefully at the applicable legal prescripts, etc., and then came up with this final report, which we believe that we have. I think Vusi has answered substantially all the other questions, so that should be fine for now.
Thank you all very much. Do we have follow-ups? Okay.
Thank you, ma'am. Moluko Moloto again from EMEA. I'm afraid, Mr. Damini, you haven't responded to my question. You instead responded to a question I did not ask. You were talking about the fact that the president, because he was not an employee or he's not an employee of Phala Phala or that company, he could not have received remunerative payment. That is not my question. My question is, since you have seen this financial register, did the president declare his financial interests, the money that was made by his company, where he is the sole director? Did he declare it in the financial register in that financial year, or since it's been 3 years now, has that been declared? That's one. Maybe educate us. Does he have to declare that in that register? But also, I would like you to respond to the fact that an inquiry that was done by Parliament, a panel chaired by the former Chief Justice, and there's a judge there, Judge Masiba, and somebody who is knowledgeable with regard to governance. They are saying that the president has a lot to answer to. Your report says otherwise. How do you explain this? And I have respect for you as an institution, but I also have respect for the former Chief Justice. He's certainly knowledgeable when it comes to the law. If you can just tell us what this contradiction, if you can simplify for us the whole economy. But lastly, I'm sure you anticipated this, that there's going to be a backlash. The people who already believe that you were going to clear the president anyway, they just never believed in your work. Are you concerned about these perceptions that you have cleared the president and Major General Rood has become the fall guy? Are you worried about these perceptions about you?
No, not at all. Good afternoon, Alex Mitchell from News 24. Just in terms of the finding that there was no work done that the President was remunerated for, did you follow money trails in coming to that finding that the President wasn't remunerated? Were money trails followed to make that finding? If not, what evidence was at your disposal?
Junior Kumano from News 24. Just to follow up on what my colleague just asked. In terms of the remuneration, there was this, you indicated that he was not remunerated, but it was more of a declaration of financial interest. What happens as a director if he decides to use that money? Will that then count as remuneration, or what happens then?
Is that all?
Yeah, that's all.
Yes. Yeah, I can see. Okay. I'll allow Advocate van der Merwe to take some of the questions and I'll round off.
Good afternoon, yes. First of all, if I may, on the issue of the Section 89 panel. Of course, the Public Protector was also reminded of the findings of the 89 panel by the complainants because they are contradictory to what was found by the Public Protector. We looked at the 89 report in several manners. First of all, the probative value, because what the panel concluded on was evidence before them. What a Public Protector is required to do is to independently source evidence. We cannot accept the findings of another body as evidence of what the Public Protector is requested to investigate. Then we also looked very carefully at the mandate and the process of the 89 panel. It was not an adjudicative body. It is a sifting process to decide if there is a case, exactly like the colleague was saying, for the President to answer to. The deciding body in that case would have been the impeachment committee, which has not yet made any findings. So the findings of the 89 panel didn't have any probative value, evidentiary value, around the same issues that the Public Protector is required to investigate in terms of the Constitution. It does not only relate to the 89 panel, it also relates to all the other institutions that are tasked to deal with this. We are balancing interest and mandates to ensure that in the end democracy and the Constitution is protected, and therefore all these bodies have different mandates but in different contexts. For the Public Protector to make a finding, it has to be impartial, independent, and without fear, favour, or prejudice. So that is as far as the 89 panel is concerned. Then secondly, the Public Protector has learned from the court cases and from guidance from jurisprudence that our mandate is confined to public money. And specifically from the CR17 matters, to go into what the President would be earning from private sources was not within the scope of the investigation. We looked at the issue of the concept of remuneration and whether the interest was declared. As I said, also, or as the acting Public Protector was saying, the issue of the objective and the purpose of these provisions of the code, not to check if the President may have earned any passive or income as such, but to look at it, what was the impact of this on his secondary interest and his primary interest. Thank you.
Thank you, Niels. Let me just add as well, when you look into the mandate of the Section 89 panel, is that they were not mandated to investigate the matter fully. Their mandate is a preliminary inquiry. Therefore, they did not summon persons to give evidence before it, or produce documents, or hold public inquiries, or any other deliberative collection of information, as opposed to what the Office of the Public Protector had done. So theirs really, as Advocate van der Merwe said, is to say whether there's a preliminary case for the president to answer. And then the impeachment inquiry is the one that does the full-scale investigation, probably close to what we would have done. And at this stage, no impeachment committee has sat to then do that full-scale inquiry. But I also want just to take out from the very same report of the Section 8-9 panel that it is noted that the scope of its powers was in fact very limited, as it lacked the power to test the reliability of the information placed before it, in particular in the absence of the power to hear evidence from persons or institutions that might have information relevant to the removal of the president from office. It was never intended that the panel should make a finding on whether the president is in fact guilty of any of the acts listed in Section 89, subsection 1. Therefore, the powers and the jurisdictions and the mandate in this instance is purely quite different. Let me just also answer, Sidi, on the fact that at which stage did I take over the matter? Advocate Mkhwebane signed off the questions that went to the president. I then managed and oversaw the investigation thereafter. So when the responses to those questions came, I was then already the acting public protector. And I must say that at the time when these questions were signed off to the president, they were based on a hearsay evidence that the public protector did not even have in her possession. So when the matter then progressed, that is when the investigators then obtained the affidavit of Mr. Fraser, but also followed up where they could on the hearsay evidence that he had provided. And as you've heard, what Mr. Dlamini said is that most of the evidence could not be followed up on because the sources were not provided, and we too could not establish who those sources are. And further, that the information was contradicted by the actual information, because the investigators went and did an inspection in loco in Phala Phala and found that the videos and the pictures that were purported to be depicting the Phala Phala house of the president were in fact not that of the house of the president, but of the neighboring farms. On the issue of the perception, of course we are worried by perception. That is why, as we have conducted this investigation, we looked intensely at law, the legal prescripts, but we also looked at work that this office has done before, and we looked into the consistency. If you look into the state capture report, there's some aspects of the matters that were referred to the other agencies, which were primarily mandated with that in terms of Section 64CI of the Public Protector Act, for instance, to the DPCI, because the Public Protector does not have the powers to investigate crime. And we have done so in this matter as well. But we did not refer because already we were interacting with these institutions, and we already knew, and it was indicative that they are already investigating these particular issues. But if you look into the matter of the former deputy president, Mr. Mabuza, which was investigated by this office and actually signed off by Advocate Mkhwebane, where it was alleged that he was involved in the procurement of motor vehicles contrary to the legal prescripts. The finding there that there was no evidence pointing directly or indirectly to him, but in fact it is the officials who had signed off on that particular procurement who were found to have acted improperly. So similarly in this matter, there is no direct or indirect evidence that points to the president. But yes, through the report that was produced by Rweda, we are able to say that they actually exceeded the bounds of merely doing an assessment for a threat analysis, but rather that it was an investigation. But from General Rweda himself, he says the president did not give him instructions of what to do. Now, where else would we have found that information when the affidavit we have from Mr. Fraser is filled with hearsay evidence which he refused to give us sources of that information, and sources which we could not establish even through the independent investigation that we have done. So I just wanted to demonstrate to you that we have acted consistently with how this office had decided on matters before. Therefore, it would really unfair and disingenuous to say that it was expected that we are going to clear the president and therefore have cleared him. I think the report is detailed enough to give a sense of how we've applied our minds in arriving at the conclusions that we've arrived at, and the legal prescripts that are applicable thereto.
There's one aspect I just want to clarify.
Okay.
Sorry, there's one aspect of the question I just wanted to clarify in respect of the issue of a company versus a closed corporation. The president is a member of the closed corporation, but in terms of the law, the closed corporation maintains an independent personality and income deriving from the activities of the closed corporation does not necessarily befall the president. It goes into the estate order as an asset of the closed corporation. And what the public protector looked at is whether from that income is there a payment or remuneration to the president from the closed corporation. And what we actually found in practice is that the Phala Phala Farm, as it was operating as a closed corporation, the president was in fact putting a lot of his own personal money into maintaining the farm and not the other way around. Thank you.
Thank you, Naz. And furthermore, I just want to clarify really the issue of going into persons' bank accounts. There must really be a reasonable suspicion or reasonable information before us that would require us to go into those bank accounts. We have learned from previous reports, and where are those reports now, where we took it upon ourselves as the Office of the Public Protector or the Public Protector to go into persons' bank accounts. But also just to clarify that the complaint was never about the financial interest. The complaint was about paid work, remunerative work, and doing that particular work. And if you carefully look into our report and the statement which I just read out, starting from whether there was work that was being done, there was day-to-day activity that the president was involved in at Phala Phala. We therefore could not make that finding, having regard to the actions, the conduct, and the definition. Now, getting into remunerative work, it couldn't have been remunerative work because he's a director in that particular company. He is not employed by that company. He's not doing day-to-day in that company, but rather he's got financial interest. And the complaint was not about financial interest in any event. Therefore, if we would have gone into the president's bank accounts, it is really our respectful submission that we would have done what we were reprimanded by the courts in the CR17 matter.
Thank you very much. This will be the last set of hands.
Thank you, Advocate. Like my colleague Molato, I felt that the tragedy did not answer the question I asked, but I wouldn't labor the issue. I'm actually going to add another date, the Advocate, into the chain of events, into the chronology. But let me take it from the beginning so that when the answer gets answered again, you know, it speaks exactly to my question. On the 10th of February 2020, there's a robbery, housebreaking at the president's farm. On the 3rd, 4th of March, the president's bodyguard interrogates the brother of the helper, who reveals information how the money was taken, who took it and what not. 3rd and 4th of March 2020. 19th June, the Inspector General of Namibia issued a statement saying that they met South African authorities at no man's land, where they informed them about the presence of these suspects in Namibia. On the 25th, 26th, the President's advisor, the President's bodyguard, and it's okay, travels to Namibia, right? Okay, they travel to Namibia. You speak to Roddy, I just saw him on the report, and he says he was never in Namibia in 19 June, according to what the Inspector General is saying. Did you verify with the Inspector General of Namibia to say this meeting that was held on no man's land on 19 June, who was there and what was their business? Because as far as we are concerned, from the statement of the Inspector General, as of 19 June, South African authorities in 2020, South African authorities, including the bodyguard of the President, had knowledge that the suspects were in Namibia. So it cannot be that we accept that General Rode abused state resources and traveled to Namibia and investigated the matter without any proper authority. But at the same time, he just went to Namibia accompanying the President advisor, and the thieves happened to be in Namibia. I'm just asking again, what connection will satisfy you? Is it a coincidence, as far as you're concerned, that all these players are in Namibia at the same time, and the information also links? Is it a coincidence, as far as you're concerned? Thanks.
Thank you so much. Francis Machado from Progressive Independent News Agency. You state in your report that the President did invest or keeps maintaining the farm, but there is no any connection of him now receiving, if I got you clearly, of now him receiving money from the farm or any benefits, direct benefits from the farm. Did you ask why he keeps investing when he does not get back? And do you maybe perhaps know when is he going to get back the benefits from that farm? Thank you.
Okay. Yeah, it is. Thank you.
So after this, thank you.
Thank you. Sitima, once more, yes, you do have a sequence of events, but what this sequence of events actually proves is evidence that we do not have. Firstly, we cannot approach the Namibian authorities because we do not have extraterritorial jurisdiction as the public protector. There is no legal prescript that grants us that jurisdiction. And the SAPS is investigating this particular issue. It is within their ambit and not within our ambit as the Office of the Public Protector. So the mere fact that there has been traveling, and also the complaint was that it was to have the suspects arrested. Now, if the suspect was already arrested, how do we then say that there is a nexus between the travel and the suspect who had already been arrested? And what would that have been for? Regarding the interrogations that were done by Remedial, we've got a finding in that respect. We are saying that it was improper conduct and therefore amounted to maladministration. Regarding the President investing in the farm, I mean, that would have meant that we are going beyond our investigation in respect of why the President is investing money into the farm, and why would he invest, and when will he get back what he's investing. It's outside the bounds of our investigation. Our investigation was whether the President performs remunerative work in respect of Phala Phala. And through the evidence that was before us and through the legal procedure evaluated that it is indeed not so. If there was any, it would have been a financial interest, considering the composition of the close corporation and his position in the close corporation. Thank you.
Thank you all very much for
asked them to buy a car and something.